You know, it's very difficult to get close to a justice, and we are not supposed to get close to anyone. Let me welcome all of you to this thrilling session on justice, voice of the voiceless. Recently, on January 28th, the Supreme Court of India celebrated its Diamond Jubilee. In the last 75 years of its existence, the Supreme Court has won both accolades and brickbats for its role as the apex court of the country. Seen as the most powerful court in the world, it has championed the fundamental rights of the people. It has protected the rights of women and children, of the minority and the prisoners. But at the same time, it has been criticized for some of its judgments, such as the Sabarimala judgment, the same-sex marriage case, and recently for its judgment on PMLA. Today, it is not just the Supreme Court, but most importantly, the entire Indian judiciary, which is under the public scrutiny. The social media reflects the frustration of the people with the judiciary. The mass media discusses and debates the performance of the judiciary on a daily basis. The disillusionment and the anger against the judiciary is but natural. On the one hand, the generational changes with the diffusion of technology and with the soaring inspiration of the people, the society is accelerating at supersonic speed. On the other hand, with antiquated procedure, with outdated laws, with deplorable infrastructure, the judiciary's speed is that of a bullock cart. Today, we will discuss just the tip of the iceberg, the role, the functioning, and the direction of the apex court. We have the pleasure of having Professor Aparna Chandra, Professor Sital Kalantry with us, the two of the three authors of his seminal book called Court on Trial, a data-driven account of the Supreme Court of India. This book critically analyzes the functioning and the works of the apex court of the country. We also have the privilege of having two eminent judges, Justice Madan Lokur and Justice S. Muralidhar with us. I'd like to begin this session, Aparna, with you. What exactly is the theme? You can just quickly summarize that for us, please.
Sure. Let me just begin, though, by thanking all the panelists for taking the time out to engage with our work and for being a constant source of inspiration, both on the bench and off it. So as Justice Chauhan was mentioning, last week marked 75 years since the court was established. And in this time, the role and the structure of the Supreme Court has changed enormously. So what started out as a small court of 8 judges taking about 1,000 cases a year is now a behemoth of 34 seats on the court, receiving about 60,000 petitions. In terms of its role, what was seen as a forum for the legal quibbling of men with long purses, and this is not me saying, this is the Supreme Court reflecting on its own role in the 1970s, saying that we've become a forum of the legal quibbling of men with long purses, today aspires to be, at least aspires to be, what we call a people's court, which is a court for the common person, providing voice to the voiceless. However, as we describe in our book, our data suggests that the court's structures and processes are often working at cross purposes with this role, with this changed role. So what the book does is that it looks at the everyday working of the court, and we look at the broader patterns, the forest and not the trees, not the specific cases, but the broader patterns of how the court is functioning, and identify the ways in which it is working at cross purposes with its role of being an accessible forum, and the gaps between intent and outcome, and then we suggest pathways for reform. So this is what the book is about, and we look at sort of different elements of the working of the judiciary in the book.
Professor Sital, in the book you make a rather paradoxical statement by saying it is easy to access the Supreme Court, but not necessarily access to justice. Could you please explain this statement to us?
Yes, thank you so much. So this way the Indian Supreme Court has viewed its role is to increase access to provide justice. So for them, more access means more justice. And in our view and our analysis, we actually think that less access to the individual might actually give more justice and more voice to the voiceless. Now you say, how is that? Right? As Professor Chandra mentioned, 60,000 people approach the court every year. 2 of the 5 working days of the court is spent listening to these people and their lawyers. Over 90% of the cases they take are discretionary, meaning they could deny them. The Constitution doesn't require them to do so, but they have usually just add one more layer of appeal, or they skip the lower courts altogether. But of these cases, right, so that crowds out its role of doing the big PILs and doing the big in constitutional cases. Less than 10% are individual rights cases or PILs or constitutional law cases. If it could spend more time on doing those, then it would have a wider impact. And if it could let the cases rest in the lower court, then it would also give people more certainty sooner. So when it takes cases, it delays judgment for an average of 3 more years. And also, in our data, we found that only 56% of the cases it takes, it reverses, right? So for the 44% of the people that have gotten in and have gotten of those decisions, nothing changes. The court says, we agree what the lower court does, we're not going to change anything, and all we've done is extended it by 3 days and cost these litigants more lawyers' fees and bringing it to Delhi. So that's how we come to the conclusion that they could have more impact by trusting lower courts, shoring up lower courts, getting local justice, and using their time to set precedent. Using their time to create rules. That's what common law courts do. US and India, the same UK tradition, they should give guidance to lower courts so lower courts have consistent norms rather than litigants just saying, hey, let's do chance. We don't know what 2 judges will decide. Let's just take it on chance. So that's how we come to the conclusion.
Thank you. Aparna, I have a question for you. Delay is endemic to the Indian judiciary. We have about 50 million cases clogging our courts throughout the country, out of which 6 million are pending in the High Court. 44 million are pending in the trial court. And according to your book, it takes about 13 years and 6 months for a case to travel, let's say, from the trial court all the way up to the apex court. What are the socioeconomic consequences of the delay?
Sorry, yeah. Just on that figure of 13 and a half years, we found that of the cases that actually get decided by the Supreme Court, which have traveled all the way from the lower court, which is a very small percentage of all the cases that are trying to get up to the Supreme Court and are just pending in the system for decades altogether. But that small percentage on average takes about 13 and a half years, and again it's spread very widely. So at the top end those cases are taking decades altogether, and at the lower end they're moving pretty fast. So on average it is 13 and a half years. We find that these cases take approximately the same amount of time in each tier of the judiciary, in the trial courts and the High Court and the Supreme Court. Now the causes of this, as Sital has already mentioned, is because the court has chosen to take on so many cases and has refused to set any clear guidelines on when it will take on these cases. So that allows for a lot of chance litigation by well-heeled parties, right? It doesn't cost them much to go to the Supreme Court and say, well, hear my case, and maybe a judge will be convinced because there is no clear guidelines. So it's a self-created issue. It crowds out, again, as Sital mentioned, some very important cases. So, for example, the most delayed cases in the Supreme Court are constitutional bench cases. And constitutional bench cases are cases which involve the most important questions about the Constitution, about holding our government to account, about interpreting the basic text of our polity. These are the most delayed cases. It's absolutely the consequence of this overwhelming sort of appellate jurisdiction that this has come about. And of course, it delays liability, right? So if someone has been wronged, it takes a longer time for them to get justice because they have to keep going to the Supreme Court. Now, one might say, well, okay, but maybe the lower courts are getting things wrong and therefore we need to go to the Supreme Court. That's not what our data suggests. The bulk of the cases are cases where the Supreme Court ends up siding with the lower courts, and the lower courts themselves have all consistently held in one way or the other. So these are decisions where all the lower courts have agreed, the Supreme Court takes it on and agrees with the lower courts, and one would wonder then what is the court doing in that admissions hearing that they spend 2 days on, on what basis are they filtering out cases when the bulk of cases that they end up taking are cases where they just agree with what the lower courts have done?
Justice Lokur, one of the suggestions made in the book is that perhaps we should have guidelines for the admission of what is termed as the special leave petitions. And for those of you who do not know what this peculiar jurisdiction is, a special leave petition can be filed against any order, judgment, or decree of any of the court or any of the tribunal. It used to be an exclusive jurisdiction which has now been applied very liberally. And as Professor Sital said, because of the large number of SLPs coming in, it is being counterproductive. So my question to you, Justice Lokur, is what sort of guidelines can be laid out? Or what are the ways and means of controlling this flood of SLP? And how practical would it be from your experience?
Yeah, thank you. Yeah, before I answer your question, a small correction. It was 50 million cases. Yesterday it became 51 million cases. All right? So it's getting from bad to worse. But anyway, the Constitution itself lays down a procedure for coming to the Supreme Court. So when you get a decision from the High Court, for example, you can go to the High Court itself and say that, give me a certificate for leave to appeal, because I think that this case of mine involves a very important constitutional issue. And then the High Court will decide whether certificate should be granted or should not be granted. That makes it that much easier, to get admission in the Supreme Court. Now, this procedure for grant of certificate for leave to appeal, as far as I know, has not been followed in the last, I don't know how many years. Probably you've looked into it. It's not been followed. So nobody applies for certificate, which means one provision of the Constitution is not being applied or has been rendered a dead letter. That is one way of limiting the number of cases that come to the Supreme Court. Second, the Constituent Assembly debates show that filing a petition for special leave to appeal under Article 136 of the Constitution is an extraordinary remedy. So you first, go through the rest of the channels, that is certificate for leave to appeal, filing a review petition, okay? And if all that doesn't work and you still feel that, yeah, it's an important case, then you go to the Supreme Court and say that, I want to come by way of special leave. It's not just leave, it is special leave. Now, and therefore, the Supreme Court should be very circumspect in allowing special leave petitions to be filed and to be taken up for consideration. There was a case, I remember, some time back, maybe 2015, 16 or something like that, where somebody had said that the Supreme Court should lay down guidelines for the exercise of jurisdiction under special leave jurisdiction under Article 136 of the Constitution. The matter came up before a bench presided over by the then Chief Justice, and they dismissed the case. I remember during lunch, some of us asked the Chief Justice what happened in that case. So he said, well, we can't lay down guidelines on when a person should come to the Supreme Court and when a person should not come to the Supreme Court, so therefore we dismissed it. That was an opportunity, I think, for the Supreme Court to lay down guidelines, and it missed that opportunity. I don't think that opportunity is going to come again. But we need not have that opportunity in view of the fact that the Constitution of India itself provides sufficient guidelines for coming to the Supreme Court. So all that the Supreme Court needs to do is follow what the Constitution says in Article 132, 133, 134. And that will limit the number of SLPs coming to the Supreme Court.
Brother Murli, one of the points made in the book is that this delay at the Supreme Court is being, in fact, used by the Supreme Court as a convenient means or tools to avoid controversial and, embarrassing cases. For example, we have the electoral bond case pending for the last 5 years. We have certain bail applications which are pending for the last 1 year. Do you think this is a fair criticism of the Supreme Court?
Yeah, I want to start off first by admiring the sign language person sitting on the dais. I always used to think that the language of the law was opaque, but I think she's disproving us. Kudos to you. And I want to lighten the mood a bit. So there's this wonderful book called Lowering the Bar by Professor Mark Galanter. And one of the funny anecdotes that he narrates there is Lord Coleridge of England, we're talking about 100 years ago, is late for the court. And he's rushed down out of his house and he hails a London cab, gets into the cab and he says, "Take me to the courts of justice." The cabbie turns around and says, "Where is that?" He says, "London cabbie, and you don't know where the court halls are?" He said, "Oh, the court halls. I thought you said courts of justice." So there's a long distance to be traveled from law to justice. And I think this book highlights some of the important issues that we are confronted with. But I want us to remind ourselves that this book is only about the Supreme Court. It's not about the high courts. It's not about, most importantly, the district judiciary. They do tremendous amount of work. While we do focus on delays in justice, what we don't talk of the work actually done by the courts in a given year. It's, I think, a big tribute to the Indian judiciary that over 10 million cases actually get decided by the Indian judiciary every year. And those judges are toiling endlessly. I'm talking of the magistrates in the smallest of the courts of the district judiciary, which is working day in and day out. And I think it will be important for us to study the actual working patterns of those courts. Second, and I think this is also important for us to discuss, which perhaps is not discussed in this book, is what is known as judicial impact assessment. When you pass a new law, what effect it has on the functioning of the courts is a less studied area. Fortunately for us, we have two committees that went into it and gave its recommendations that before the parliament passes a law, let's for instance take this Unlawful Activities Prevention Act and the amendments made to that act. That one act is having a tremendous impact on the functioning of the judiciary. People are unable to get bail. They have to repeatedly travel between the trial court and the high court and back to the trial court. When they don't get relief of even, I'm talking of Father Stan Swami not being able to even get a straw in a jail, and for him having to go all the way to the Supreme Court for that. That is something that we need to talk about, that we do not focus on the burdens placed on the judiciary in taking up cases. To answer your point, this is what comes out of having a polyvocal court. Just like Justice Lokur just now said, the Constitution is very clear on the kind of cases you should admit. The fact of the matter is that today we have 17 benches of the Supreme Court of India. And it's not an unfair criticism that we have 17 Supreme Courts of India. So two judges need not view the issue the same way as some other two judges will. And we are seeing this play day in and day out. So one problem itself created is the large number of benches. Nowhere else in the world do you have a Supreme Court having 17 benches. I have not heard of it. Most Supreme Courts sit in benches of two courts, or they mostly sit en banc. But this is causing a problem in the quick reversals of judgments of the Supreme Court that we're witnessing in the last 10 years. And so much power concentrated in the Chief Justice of India in deciding priorities of cases. So you are right that some cases which should have deserved the priority are not being given the priority. But it's also the perception of the judge before whom the papers are placed as to what deserves priority over which other case. So this is a matter for debate, and I'm happy that Aparna and Sital have flagged some of these concerns.
I'm so glad you have spoken about the CGI being the master of the roster, because this takes me to the next set of questions. And both of you, Professor Sital and Professor Aparna, please feel free who wants to answer this question. According to you, in 88% of the Constitution bench, the bench is headed by the CGI. And according to you, whichever way the CGI tells, so tells the bench. Then are we saying that the decision of a constitutional bench is a foregone conclusion?
So the data would suggest. And let me explain for the audience what this means. So the Chief Justice of India for the Supreme Court is the master of the roster. That means essentially that the Chief Justice constitutes the bench that will hear a particular case. Now, brushing aside other complexities, when it comes to a constitution bench, which is of 5 or more judges that have to hear important constitutional matters, the Chief Justice gets to decide who will sit on that bench of 5 judges and when that bench will sit. So, for example, the concern about judicial evasion, you don't set up a bench, you don't decide the case. Sometimes the case decides itself. It becomes a fait accompli. Perhaps we saw something along those lines happening with the Article 370 case when it's decided 5 years after the event. But the Chief Justice decides who sits on the bench. And what our data suggests is that the Chief Justices over-assign these cases to themselves. So they are on 88% of those benches. The next senior most judge is on the bench about 4 times less likely to be on a constitution bench as compared to the Chief Justice. They put themselves on most of these benches. And then the benches that Chief Justices constitute, surprise, surprise, tend to side with the Chief Justice. So, till date, from 1950 onwards, Chief Justices of India have been in the minority in a constitution bench case only 13 times, and I'm talking about nearly 2,000 constitution bench judgments where they have been in a minority only 13 times, none in our period of study. That means that the Chief Justice of India has the power that no other judge does to always carry the bench with them. And hence the concern of bench stacking, that you're assigning judges to the bench in a way with an eye to outcome. This is not something that we are the only ones who've said so. I mean, judges of the Supreme Court in the past have raised concerns about bench stacking, including very famously the press conference, of which I don't want to say anything more, but the press conference that 4 of the judges of the Supreme Court did, as well as judges of the Supreme Court in the past who alluded to this concern.
Justice Lokur, there has been recently a tussle between the bar and the bench with regard to the assignment of cases to particular bench or to particular judge. Recently, your statement is, and I quote, "If all the judges are equal, then raise the question of assigning special cases to a particular judge." My question to you, Justice Lokur, is, then how does one circumscribe this power of assignment of the chief?
Yeah. Okay, there are 2 answers to this. Somebody has to assign cases, all right? So the concept of master of the roster will exist whether you like it or not. Somebody has to do it. If not the Chief Justice, maybe the registrar. If not the registrar, maybe somebody else. But the 2 answers that I have, one is the use of technology. Okay, you can limit the exercise of power by the Chief Justice through the use of technology. Now, I remember, when I was in charge of the computer committee in the Supreme Court, I had wanted to do that, assign cases through the computer. But the registry told me that 36 different instructions had been given by various Chief Justices from time to time, and some of them are in conflict with each other. And if we try to implement those, first of all, it's going to be impossible. Second, even if we do it, the computers are going to crash. Okay? So that never happened. But the point really that I think is that even if the power is given to the Chief Justice, and the Chief Justice does have that power, whether it's in the Supreme Court or whether it's in the High Court, it must be exercised fairly and reasonably. Not that all the cases of a particular kind should go only to a particular judge. Aparna was talking about that so-called press conference. I was one of the participants in that press conference. And this is what we had said, and this is what we had wanted to convey. That, sure, you have the power, but use your discretion fairly and properly and reasonably. Okay? It's not that all cases of a particular type, may be politically sensitive, maybe pertaining to liberty, maybe pertaining to something else, should go only to a particular judge. All judges are equal. Why can't it be given to any judge? Why only to a particular judge? Yeah?
Professor Sital, one of the most interesting chapter of the book is about social diversity or the lack of it in the Supreme Court. Interestingly, despite the fact that women form 48.5% of our population, in the last 75 years, out of 266 judges who have sat at the Supreme Court, there have only been 11 women judges, including the present 3 ones. Do you think that the collegium suffers from a patriarchal syndrome?
Okay. Well, so what I can tell you is what we saw, right? So the collegium, just for people who maybe are outsiders, this is going to shock you. So how do the appointments work at the Supreme Court? The judges appoint themselves. The Chief Justice of India and 4 senior-most judges nominate other judges. And typically, occasionally not, the executive will ratify it. And they do this in secrecy. They do this, sometimes they might issue a little note, this is what we talked about, but we don't know. Why did some of the wonderful justices sitting here get appointed, not appointed, some of them get appointed? No idea. So we just looked at what are the social aspects. So we've just, and just to be fair, right, they created this collegium in 1993 in response to some court stacking that Indira Gandhi and others had done. So they thought, let's take this out of the executive. But the Supreme Court also rejected a reformation, which is to have a judicial commission. So this is where we are. And their appointments, the post-93, reflect the regional diversity of India, of the different states. It accurately reflects the religious diversity of India, but it hasn't reflected the caste and the gender diversity of India. As we said, 5 scheduled castes, 11 women have been members of the court. And what's more curious, so we looked at where do these judges come from? So about 86% of these judges are High Court Chief Justices, right? Who the Supreme Court appoints. So you would think when you find a woman who's a High Court Chief Justice, appoint her, because she's already made it. She's obviously good enough to be that high. But they do not. They do not. They appoint more male Chief Court Justices, High Court Chief Justices, than they do female. Not statistically significantly different, but about 30% of the judges that are male High Court Chief Justices that get appointed, and only about 26% that are female. So why? And I can tell you notable examples, right? Justice Geeta Mittal, Chief Justice of the Kashmir High Court, Chief Justice of the Delhi High Court. Why would she not appointed? So my point is that the Indians' notion of diversity has changed, right? With the Mandal Commission, with the Parliament, reservations are everywhere in every aspect of Indian society, education, lower judiciary, but because this process is so insulated from the political branches, they can do whatever they want. They're not transparent, nor is there accountability. So that's where we hope that we can see some change with the court. So whether they're patriarchal or not, that's for you all to judge.
So you're leaving that question as an open-ended question. Thank you.
I'd like to add the name
Yes,
of
please.
Justice Leela Seth. Right, she was also overlooked as Chief Justice as a judge of the Supreme Court. Justice Leela Seth was the first woman Chief Justice, and she was the Chief Justice of Delhi High Court, a brilliant judge, brilliant lawyer, but not appointed to the Supreme Court.
Please.
Can I just interject to nuance the issue? I think some people will agree with me that women subscribe to patriarchy. So merely appointing women does not deal with the patriarchy syndrome. I think that's something that we need to understand. And I think empirical studies will show you that. I say this because we had an all-women police station in Agra. And you had a large number of instances of custodial violence from that police station. So there is no guarantee. And for instance, there was a demand that rape trials should be presided over only by female judges. And I had a different point of view. I said we need to sensitize male judges to conduct rape trials where they'll inspire confidence in the litigants. So I think we need to nuance this a bit.
No, I agree there's no guarantee, but there is no reason there shouldn't
And
be
then
more equality.
the second point is about insulation. The popular myth is judges are appointing judges. Actually, it's not true. We have a situation here where the judiciary is in fact not insulated from the other branches. There are a series of informal consultations that go on before you agree on a list of names which will be finally approved for appointment. You're seeing it play out. Some names are just not passed, although they are reiterated by the Supreme Court Collegium. So what you say is right. The judges are able to appoint themselves. Then we should have every decision of the Supreme Court Collegium resulting in an appointment. And it's not happening. So I think this is something that you will need to reflect on. And all of us to reflect on that today we don't have a judiciary that's completely insulated from executive interference.
So, if I may, which therefore ends up combining the worst of both systems, right? The of executive interference in the judiciary and judicial appointments, which is a problem, and opacity of the collegium, which is anyway a problem, so that we don't get to see what is happening behind the scenes, and that it is actually being influenced by executive pressures, or at least some executive conversations with the executive, which was not supposed to be the case. So it combines the worst of both systems, of collegium and of executive-led appointments.
Sorry.
Please,
Sorry.
please, sir.
I think the executive government is far more opaque than the collegium, than the Supreme Court Collegium, right? On what basis does the executive say that, listen, we are not going to appoint a person? You know, they don't even bother to give reasons. And when they do give, some sort of a reason, and the collegium says we don't agree, they say, all right, you may not agree, but we are still not going to appoint that person. So I think the executive government is 10 times more opaque than the collegium.
My next question is out of the syllabus. This is an area that the book does not cover, but it is very essential and a fundamental question today. Is the impact of information technology, and especially of artificial intelligence, on the Indian judiciary? How do you think it's going to impact us? Professor Sital, would you like to explain with your American experience?
Sure. Yeah, I think that we can't avoid it. So some higher education institutions or lower education institutions have said, we're going to ban the use of generative AI because we just don't know how to control it. I think we have to work with it. Our students have access, there's certain types of AI. There's AI that'll help search cases, and that's a great efficient thing. Better, if we can find similar cases easier, that's great. Then there's generative AI, which might help you write briefs. And we've seen the consequences of that. The technology is not there yet. They have these hallucinations where there's fake cases being cited. There are a poor lawyer named Steve submitted a brief written by ChatGPT, and now he's being sanctioned because he cited fake cases. So we have to know where its limitations are and how it can use it. And so we have to train our students to do it rather than to just think of it as a form of cheating or plagiarism, which it can be, but we need to reflect on it more in a more nuanced way.
Brother Murli, you were the one who led the bringing in, you literally ushered in information technology, first at the Delhi High Court, and you're famously known as the Chief Justice of Orissa, who has now made all the districts of Orissa and all the district courts of Orissa paperless. Therefore, my question to you, number one, do you think information technology and AI is the panacea for all our judicial vows?
Yeah, I think that's a no-brainer, and the answer is no. All of this is a tool, and it's important that you control the tool rather than the other way around. So how you use this tool and how do you use it to improve your functioning is up to you, the kind of choices you make and the decisions you make. For instance, analyzing data, collating data, the National Judicial Data Grid, that Justice Lokur should be credited with single-handedly spearheading that whole exercise and making available granular data on the working of the district judiciary available to the entire country. So that's a good use of technology to analyze statistics on pendency of cases and on scheduling of cases. Now, as a judge, I need to plan my day, right? I need to know how many cases before me are more than 10 years old, more than 5 years old. If I am a criminal court, I should know how many of the litigants before me in today's cases are in jail, having been denied bail earlier. So I should know how to prioritize cases. So technology helps in that. As a Chief Justice, I need to know of the criminal appeals, how many of the appellants are still in jail having served more than 10 years, and their appeals need prioritizing. So I can use technology to streamline the planning, case management, court management processes. But using artificial intelligence to substitute decision making is simply an unacceptable proposition. And the second danger is confidentiality and privacy. We are a repository of extremely sensitive data in the judiciary, and to make that freely available will be a huge problem. Here I need to just explain to you what the National Judicial Data Grid does is tell you for this case number, which is the next date, how many times has it been listed. But that will not tell you the details of the case, the actual pleadings as we call it in legal jargon, what was said by the petitioner, what was said by the respondent. That is always kept confidential because it involves privacy and personal lives of many. So technology should be carefully handled. We cannot allow technology to substitute decision making. And third, very important in the Indian context, not just for the judiciary, our data is not reliable data. We make too many mistakes in entering data, and if we do not account for that, we could have serious miscarriages of justice by applying technology without actually cleaning up data. So one big exercise in Orissa was to clean up the data. And I must therefore say that while it is useful as a tool, it's definitely improving the efficiency of judges and making the court space less chaotic. We should be careful in how we approach artificial intelligence to substitute what judges should be doing as part of their essential function.
So your take is that let's have more faith on the natural intelligence rather than the artificial one. I'm sure all of you are just dying to cross-examine 3 judges and 2 eminent lawyers. So I'll now open the floor for question and answer. My only request to everyone is please make sure your answers are, your questions are as crisp as possible because we are running out of time. May I have somebody hand over the mic to the lady in the last with her hands up, please?
My question is, how is the Supreme Court going to protect its place in being replaced in the committee of selection of the Chief Election Commission now that the bill has been passed in Rajya Sabha? What are the strategies Supreme Court is already thinking of to protect its place?
Ma'am, if I may request, I would rather that you don't ask any question about a case which is sub judice, that is, that a case is still pending before the Honorable Supreme Court. It would not be proper for us to express any opinion on that. Just may I request the young lady in the blue sweater in the front. Yes, ma'am.
Excuse me for asking this. I think why can't we...
I can't hear you, madam.
Ma'am, can't hear you. Could you
Why
please?
can't we increase the working days of the courts when so many millions of cases are pending? Excuse me for asking this.
Can we have two more questions and then we'll take three questions? Yes, sir, you're in the front. Please go ahead.
Sir, to your point that particular cases should not go. I mean, the cases should go equally to all the judges, and every judge should be.
Sir, you're hardly audible. Could you just take it closer to your?
Sorry, sir.
Yes, please.
So, to your point that the cases should go to all the judges, and there should not be all the judges are competent to hear a particular kind of case. So to that point, I just wanted to say that there are certain judges who excel and understand the stream of law, and would it not be prudent that those cases should go to them, because it takes a while for a judge to understand a new stream of law. So therefore, does it make sense? And then cases being assigned through a AI or something, rather than through a roster.
I'll take the third question from the lady in the middle with the printed topper. Yes, please.
As a law student, I feel like all of us have the privilege of kind of understanding what the judgments say, what the rules are coming, and all of that. But do you think that there is a very substantial need for this privilege for people to even access law, even in terms of what you mentioned, how the collegium chooses? So we know about how the letter came, the infamous case of Kirpal getting chosen and not getting chosen. Along with that, and also nepotism that happens in law. So privilege and nepotism, thank you.
I'll request Brother Murali to take the first question about why have so many vacations and why not increase the workload or the working days of the court.
Yeah, actually there's a popular misconception of what judges do. Many of the audience probably feels that once the court working hours ends at 4:30, the judges are away to do free things, whatever they want to. It's far from true. Actually, the work of the judge begins after the court hearings end, when some longish orders are dictated, orders that have been dictated in court are corrected. Judges sit in administrative committees for the administration of the court. Many judges don't return home till 9:30 in the evening. And I'm saying this out of personal experience of being more than 17 years as a judge of a high courts. The second thing is, judging itself can be very, very emotionally draining. It's cerebral work, it's emotionally draining as well. And being decisive, saying yes or no, saying I believe this witness and I don't believe that witness, requires a lot of reflection, thinking, and clear understanding of facts and principles, and also a very quiet place to reflect. Now, the court space itself has become very chaotic, too many cases, and there's a lot of pressure on judges. I would hazard, in fact, that's one area that we have not studied enough, the mental health of judges. What this kind of pressure on the judge brings to bear on the functioning of judges. I would urge you not to question the vacations that the courts have. I must end on a very humorous anecdote. Rajaji was the Chief Minister of Madras, and in the early 50s. And in the assembly, one of the MLAs raised this very question that this lady asked, why do judges need so many vacations? And Rajaji said, at least there will be so many days when there is no injustice done.
Justice Lokur, would you like to answer the second question about assignment of cases? We have already discussed that topic, but if you'd like to add anything further, sir.
Yeah, I think, I have not said really that, the expertise of a judge should be overlooked. I have not suggested that. Yes, you are right. There are some judges who have done a lot of, criminal work or a lot of tax work, and they should be put in a tax bench or a criminal bench. That's fine. But, you have to balance it in one way, because it may happen that, after all, judges are also human, okay? So they also have some biases. So if you ask a judge to sit in a particular, jurisdiction for a very long period of time, you know, all the judgments may be going in a particular way. I will tell you about a judge in the 1980s in the Supreme Court, 100% pro-tenant, 100% pro-tenant. And somebody told me, I don't believe that person. He said this judge gave only one judgment in favor of the landlord. Right? In my view, that judge did not give even one judgment in favor of the landlord. All of them were in favor of the tenant. So, you know, people started going to the registry and saying that, listen, I'm appearing for the tenant, please put my case before this particular judge. That's the danger that you have. Okay? So yes, you should take advantage of the judge's expertise in a field, but not forever.
Professor Aparna and Professor Sital, the last question. Does your data suggest that collegium may or perhaps is indulging in nepotism when it recommends the name, or the data is against that impression in the mind of the public?
So frankly, we did not study that particular question. So, I mean, we could hazard a guess from generally knowing a little bit, having an insider's perspective on the legal system, that nepotism and of different varieties, right? It's also, you know, we call our chapter on diversity people like us. And that people like us is a broader nepotistic sort of idea of people in the know, people who are on the inside, not just familial relations, that really impacts appointments. And to that extent, definitely, it suggests that there are in-groups and out-groups, and in-folks and out-folks who will never get a chance, regardless of how good they are, will never get a chance to make it into the judicial system.
I understand that our answers have to be very limited.
So just to close up, I just wanted to say that our goal here is to say that the Supreme Court has been an amazing 75-year history, but it's time to evaluate the next 75 years. And we think that some of the tweaks and changes that our analysis suggests will make it even stronger to stand up to the executive, stronger to give voice to the voiceless. And I think that these are things that require will. If they have the will, I think these changes, and I hope that the court does become stronger, and I think it can through some of our policy recommendations.
Well, thank you to all the panelists, and may I ask all of you to put a big hand for the eminent